Good morning, Mr. Lecuit. I think you tried to bluff yourself through this one a little bit. Yeah, come on. You can't bluff an old man. Okay, let's talk about it. You're not graded on APA. So I'm going to make APA remarks only because you do need to understand APA, how to use it properly. Your font, let me get it as close as I can to the camera. Hold on. See that font? Now look at this font. They're different. You have to keep your fonts exactly the same. Do not change them. Keep them the same. All right, here's what I meant. Okay, page 2, an APA format, you need a title immediately centered above the line of your first text. Case background, okay? APA format, you cannot cite 403 Federal 2nd 904. You have to cite Burger King versus Hoots. That's a Burger King case. And let's see. And in-text citations do not allow for the placement of the entire citation in the in-text. Okay. And your references are improperly cited. That's enough of that APA stuff. Now let's talk about the fun part. You confused me. Here's how you did it. Here's what you need to do. In all your writing, you need to give your reader a timeline on these kinds of issues. Let me discuss what you needed. 1. When did the Hoots open their first restaurant named Burger King? When did the Hoots file for trademark protection in the state of Illinois? When did Burger King of Florida, changed its name later, open their first restaurant? When did Burger King of Florida, change their name later, file for protection under the Lanham Act? When was the first lawsuit filed by Hoots versus Burger King? You didn't cite that one. When was the lawsuit filed, which you did cite, 403 Federal 2nd, it was filed in 1968, Burger King versus Hoots? What was the result of the Hoots versus Burger King case? That case allowed the Hoots to get the 20-mile diameter radius, okay, within 20 miles. Then why did Burger King sue Hoots? Because Hoots built a restaurant outside of the 20-mile area, knowing that Burger King of Florida had filed under the Lanham Act. They were aware of it. They got caught with their hand in the cookie jar. I didn't see that. Why did I not see that? Because you didn't read both cases. Okay. I don't mean to play I gotcha, but the point is, when you write for your boss, you don't want your boss to catch you in something like that. So research. As far as your writing, perfect. Okay? Just follow those APA rules. You don't cite the case like you did 403, so forth. Now, may I recommend, a lot of people do this, and it's pretty amateurish, which you can fix in one unit. Look at your page 3 under similar case comparison. A similar case comparison and judgment. By the way, did you know that if you misspell judgment in law school, they'll fail your paper? How do you spell judgment? There is no E in it. Well, there is one E. There are not two E's in the word judgment. There is no E after judge. Okay. Thomas versus Holloway. Okay. In writing, using APA research, well, you already know, don't use the 366 F second. That goes at the back of the paper in the references. Similar to a case, instead of calling it Thompson versus Holloway, describe the facts of the case. And so therefore you would write a similar comparison and judgment, if you want to, Judgment, can be made using a gentleman by the name of John Thompson, who owned and operated a series of food chains, you want a holiday house, and so forth. Then put your reference at the end of your fact sentence. And you say, but Judge Phones, that's so stilted. Why all that writing? You don't want your bosses slowed down by having to read Thompson versus Holloway 366 and so forth, or using a case name. Use the actual facts from the case. It reads smoother. This one's a hard example. Let me give you another example. Our textbook says, well, textbooks don't talk. Kubesic reported in his textbook, no, the Board of Editorials did. The court in the court in Hutz versus Burger King reported yada, yada, yada. No, they didn't. It was testimony in the case. Am I being picky? Yeah. I'm being picky because I want you to be picky when you write. Other than that, when your boss asks you about the trademark, don't get off into the patent office and so forth. Patent is entirely different. Matter of fact, attorneys need a postdoctorate degree in patents not in order to, but it really helps them. In trademark patents, there is a postdoctorate degree. My postdoctorate degree is in international law, but there are some guys and gals who specialize strictly in patents and trademarks. That's how complicated the issue is. That's enough picking on you for an otherwise A paper. That's what happens when you're a good writer, Mr. Lecuit, excuse me. And it's important that you continue to learn something in this course rather than just get your ticket punched. As you know, as we've discussed before, you could get that done very easily with your background. So if you have any questions on what I discussed in this, or if I didn't make it clear, let me know. We'll be glad to talk.